Hi there, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our immigration show with updates. Today we're going to be talking about the bringing over your child. So if you're a U.S. citizen or lawful permanent resident and you want to bring your child here, or your child's already here, you want to know about the different processes, how they qualify, how their age affects them, watch this video till the end because that's what we're going to be talking about. So first of all, let's talk about where your child falls within the different preference categories or as an immediate relative. First, I'm going to talk about immediate relatives. So immediate relatives are in three categories. One would be if you have a child that is 21, under the age of 21, and they're unmarried, they're going to qualify as an immediate relative. Two other immediate relative categories are if you're the spouse of a U.S. citizen or if you're the parent of a child who's the age of 21 or older. So why is this important? This is important because if you're an immediate relative, you don't have to be subject to the quotas, to the numerical limitations of the preference categories. And I'm going to talk about the preference categories a little bit further down the road in this video. So right now I'm going to continue to talk about immediate relatives. So if your child is not married and under the age of 21, they're going to be considered an immediate relative. So now what happens if this isn't the case? Well, let's look at the preference categories. There's three main preferences that are going to apply to children. And the reason this is important is because, first of all, we need to make sure that they qualify as either an immediate relative or a preference category. But if they're in a preference category, they're going to be subject to numerical limitations, quotas, because there's only a certain amount of immigrant visas that are available at a time. So let's talk about some of those preference categories. Contrary to the immediate relative category, there's the first preference category where you're a U.S. citizen and your child is over the age of 21 or older. And in that situation, they're going to be in the first preference category. So the way that you determine how long it's going to take to be able to bring your child over, or if your child's here, have them get a green card, is by looking at the visa bulletin. So if the visa bulletin says C, that means it's current. If it's not current, typically for this category is usually not current, but you want to check the visa bulletin to evaluate that. So if it's not current, then that means then you're going to have to wait until the priority date becomes current. Now we're going to move on to preference category 2. Now this applies to lawful permanent residents. So if you're a green card holder, good news is you can bring your child over, but it does take some time. And there's two preference categories. There's preference 2A and there's preference 2B. So 2A are spouses of lawful permanent residents and children under the age of 21. And 2B is if your child is 21 and older and unmarried. So if this applies to you, you could bring your child over if you're a lawful permanent resident. And then finally, we have the third preference category. This is if your child is married. So in this situation, if your child's married, then they would fall under the third preference. All right, so now you have an idea of how long it could take based off of the different preference categories, or if they're an immediate relative, to determine the time you want to look at the visa bulletin, because that's changing all of the time. And now we're going to move on to the different types of processes to bring your child over. So it's also important with that third preference to note that you have to be the child of a U.S. citizen. Now, the reason that immediate relatives are faster is not because the processing times are faster, it's because they're not subject to numerical limitations. There's still processing times with the application, which still seems like a long time because it is. But that's how long it takes for the government to process the application, not because of the fact that you're waiting for the numbers to become available. All right, so now I'm going to talk about the adjustment of status process, getting a green card for your child. So if you're a U.S. citizen and you're filing for your child, you can file a one-step green card, and there's a couple of things that you need to be aware of. First of all, your child needs to have entered with inspection, so they need to demonstrate that with an I-94. Passport entry stamps are another form of evidence as well, but definitely the I-94 is the most important. Along with that is that your child should not be coming into the United States with the intent to stay in the United States. If that is the case, then you should look at the immigrant visa process. So this is specifically applying for the green card. There's this concept of preconceived intent to be aware of, and there's the 30, 60, 90-day rule, and there is also that was the prior law. So now there's the 90-day rule, which looks at what are the steps that are taken to get a green card to permanently stay in the United States upon entering. A green card application can be filed for them with the Form I-130, Form 485, work authorization if that's applicable, and travel document, self-sufficiency documentation in the form, the affidavit of support, and you want to make sure all the forms, the immigration law is always changing, so check the USCIS.gov website. Those will outline all of the forms. We'll try to give you the main forms on this video, but you always want to check that because immigration law is always changing. So along with that, you have to show evidence of the relationship, which is demonstrated by the birth certificate. That's going to be extremely important with that application, is both of your birth certificates. That is going to help demonstrate your relationship. And now if birth certificates are not available, there's going to need to be secondary evidence that is provided along with evidence from that government agency that you're not able to get the birth certificate as well. All right, so you submit all of those documents. Because you're an immediate relative, you can file the 485 application with the petition. So normally if you were under a preference category, if the priority date was not current, you only could file the I-130 petition. So there's other documentation as well that goes along with the application that you will want to check the instructions for on the forms, but you'll submit all of that to USCIS at your local service center. And the way that you can determine that is on the USCIS.gov website, looking at where you specifically live. It'll tell you where to specifically apply. All right, so then you apply, then there's biometrics, and then you'll be scheduled for an interview. Both of you should attend the interview. Normally, interviews are getting scheduled about a month ahead of time. It's been a little bit of a shorter window with COVID, but after COVID's over, that will hopefully change so you have more notice. Then you have the interview, and then at the time of the interview, normally what I'm seeing is they're not issuing green cards at the time of interview. They're putting it under review, but then the green card is issued after that. I'm usually seeing it within about 1 to 2 months, and this is always changing depending upon government processing times. That's as of today. So that is the green card process in the United States. So where this also becomes a possibility is if you're bringing your spouse over and then your spouse wants to bring their child over, well, they need a separate application, this whole green card application. Their green card application is not part of your spouse's green card application. So that's really important to know. Now that is a little bit different than if you're filing for a fiancé visa where your child is included with the fiancé visa petition. However, the DS forms are also separate for the child. Now, let's look at the process for an immigrant visa. Let's say your child is abroad. That process is called consular processing, filing an immigrant visa for your child abroad. So what that process looks like is filing an I-130 at your local service center. After that I-130 petition is approved, then it goes to the National Visa Center where they will want the affidavit of support, typically income of self-sufficiency, other documents that they'll request. Once you give everything to them, they're very picky, so they may come back and say, no, I don't like this, don't like that. And then once that's finalized, you'll be scheduled for an interview with the U.S. Embassy. Then your child will go to that interview. So that will be the final step of the process. Then they enter with a green card. So those are the two different processes depending upon if your child's in the United States or if your child's abroad. So if your child, again, as I mentioned, your child shouldn't be coming in with the intent to stay in the United States. The appropriate process for that is the immigrant visa. But if your child's already here, then the appropriate process would be filing for a green card in the United States, as long as they didn't come in with that intent. So I hope this video served you. Hope it answers some questions, and you can post your comments below. Please like this video. If you liked it, I put a lot of work into trying to make it valuable for you. And if you would like a video about a specific topic, post that below too. You are amazing for trying to better yourself, bettering your family by watching this video, getting informed, trying to do the right thing. So thank you, and I will see you soon. Bye for now.